Hi everyone, welcome back to the IDPC podcast. Last time we spoke about the role of the IDPC and AI, and today we're diving deeper into how artificial intelligence connects with people's fundamental rights. We'll be chatting about the recent FRIA Workshop, what fundamental rights impact assessments are all about, and how they help make AI more trustworthy and transparent. So let's jump in. I welcome again the Information and Data Protection Commissioner himself, Ian Deguara.
Hello, Franco, and warm welcome to our listeners. Always happy to be on our podcast.
Thank you for being here. So as I said earlier, in episode 1, we talked about the role of the IDPC and focus on artificial intelligence and the AI Act. Since then, the IDPC organized a really successful workshop on Fundamental Rights Impact Assessment, or FRIA. Could you start by giving us a quick rundown of what we mean by fundamental rights in the context of AI and data protection, and maybe explain the importance of conducting an impact assessment?
Yes, indeed. Thank you very much for the question. There is a requirement on deployers who are deploying high-risk AI systems to conduct a fundamental rights impact assessment. This requirement is incumbent on deployers who are public bodies governed by public law, but also to private entities which provide public services. An impact assessment, an FRIA, similar to a DPIA, is a tool. It is not just, as many might think, a burden. It is a tool which actually helps controllers in the case of data protection under GDPR and deployers under the AI Act to identify the risks, because this is the ultimate scope of conducting an impact assessment, to identify the risks, take the mitigation measures to address those risks, and then do a reassessment. So it's a cycle, it's a cycle where the risks are identified, mitigation measures are implemented, and then there is the reassessment, so that the controller or the deployer will actually assess and determine whether those risks and harms to the fundamental rights are still present. Last point is that an impact assessment, an FRIA or DPIA, should never be considered to be a tick box exercise. As I said, it should be considered to be as a tool, as an important tool, which will actually help controllers and deployers to identify those risks and therefore be able to present to the individuals systems and applications which do actually ensure respect and guarantees to their fundamental rights.
Could you tell us about the workshop itself?
Yes, indeed. So around 2 weeks ago, we have organized a workshop together with Professor Mantelero. We will explain later on what was his involvement in this project. So we organized this event. I believe from the feedback that we have received that it was a very positive event. The content was well structured and was well received by the participants. In essence, the workshop, the event, was to give a flavor to the audience what is a fundamental rights impact assessment and what is the interplay between the AI Act and the GDPR. Then we had a panel discussion, which was really interesting. And then Professor Mantelero presented this model, the methodology which he has developed and led as a project together with the Catalan Data Protection Authority, which is actually based on guiding questionnaires and matrices rather than on values and ranges. And Professor Mantelero explained the reasons why. The model, this model is based on matrices rather than on ranges. And then we have given the opportunity to participants to actually implement this methodology, this model, to use cases. And we managed to split the audience into groups of 10. They were provided with a use case. We had a variety of use cases ranging from education, human resources, healthcare. And they were given guidance by Professor Mantelero how to actually apply the methodology which he had presented before to those use cases, and then reach out a result. So essentially the result would be what would be the impact, the likelihood, the severity on the fundamental rights of individuals.
So Professor Mantelero played a key role in the event. What was his feedback that he gave to the groups when they presented their feedback on these cases?
Actually, to be honest, he was really happy with the results, because I would like to stress two important points. First one, this is the methodology, the model, and here I'm not promoting this model in any way, and this was made fairly clear by Professor Mantelero as well. There are no monies involved, so there is no profit, no anything. So this was actually the first model, a FRIA model, which was presented earlier this year, actually in January of this year. But this is not and will not be the only model. For instance, the AI office will be developing another FRIA methodology or model, and most probably there will be other models or methodologies. So this is not the only one, but we have presented this model because this is one which exists. It has proven through the application of use cases, which actually delivers good results, because it is very much contextual and it is very specific to the AI, to the high-risk AI system or model on which it is implemented. So that is the first point. And second point is that although to conduct these kind of assessments, naturally it follows that the responsible persons should have a degree of experience and expertise in the legal and the technical and data sciences. This model presents an easy way how, even though one might not have all this level of expertise, but they could still be able to achieve good results. So you don't need to be a scientist to implement this methodology, this model, to a high-risk AI system. Having said that, a degree of knowledge of data protection, of AI, of risk models is essential, because I always say you need to have a variety of ingredients to have, you know, to have a mix to get a good recipe, you know, and this is the case here.
Good. I think part of the event was also an engaging panel discussion with several experts in the field. What stood out from that discussion, and what were the major takeaways or points that resonated most with the audience?
We had I think we had a good lineup of panelists, ranging from academia, industry. There were many points on which we have touched, primarily the notion of regulating artificial intelligence, whether it is necessary, whether it's not, because the perception out there is that there are countries which do not have any kind of regulation and they are flourishing ahead, you know. So we tried to address that point. We discussed also the notion of shadow AI. Shadow AI meaning the use, or actually employees. So here we are talking about the employment context, employees who actually use these applications. And when using these applications, they actually put in or upload in the prompt company-sensitive information which might be copyrighted, or otherwise there is intellectual property on that information which might constitute personal data. And therefore, those are the risks which are out there. And this is happening because employers are not informing their employees. And actually, then we discuss the importance of having the right data governance frameworks in place, because this is part also of the requirements under the AI Act, to have governance frameworks in place. And as part of this governance structure, policies and procedures are essential in order to inform and actually guide employees what they can, what they cannot do with company information, because setting apart sensitive or commercially sensitive information or confidential information from a GDPR perspective, when we are speaking about personal data, there is a risk. And this is the notion of shadow AI surrounds this, where, for instance, I am an employee working in an HR function, and in order to be more productive, to demonstrate to my employer that I am able to fulfill more tasks more efficiently, more effective, I use online Gen AI tools, you know, freely available, and upload personal data onto this AI model in order to achieve certain results, you know. But perhaps people do not have the understanding that whatever is being put on these models, I mean, it's going to be used as training data, and perhaps that will be generated as results when other users query perhaps something which is related and might get that information. So we touch based on this notion of shadow AI, and also therefore the importance of having the governance framework in place. We also discussed the importance of impact assessments, of the GDPR as an enabler to innovation, not as a way to stifle innovation, because it is also, there's also this wrong perception that perhaps GDPR or data protection law is there to stop, to stifle innovation or processing activities, which is not the case. So we had this discussion,
very engaging.
also on relating to bias in training data, and the importance of having human oversight in all this in this ecosystem. So the discussion was very engaging, I believe, from feedback which we have received. And you know, Franco, the audience was really happy with what the panelists have actually said. So I believe that all in all, it was very engaging and positive.
Interesting. And finally, looking ahead, how should developers ensure that AI systems are developed in a human-centric way to protect people's fundamental rights?
I would mention 3 points, which I believe are essential. Building systems and applications by design, and taking into consideration data protection requirements. And this should be by design. It shouldn't be an afterthought. So when building a new system, a new application, by design, so from the very start, developers must have in mind that this system should be built on those principles. because at times when we speak about technology and innovation, there might be the risk that technologists or developers might rush ahead, to gain a competitive edge, But then that might result into having certain issues at a later stage. And in order to address those issues, and those issues might be very important, might be regulatory enforcement, might include risks to the reputation in case of breaches or infringement, So it should never be an afterthought. By design, from the very start, data protection considerations and even requirements in terms of the AI Act should be built in from the very start. First point. Second point, conducting impact assessments. Whether data protection impact assessment or actually I would say fundamental rights impact assessment, because when we speak about high risk systems under the GDPR, controllers are required to conduct a data protection impact assessment. High risk AI systems under the AI Act also require an impact assessment, the fundamental rights impact assessment, and in the AI Act, Article 27 actually establishes the complementarity of these two impact assessments, because it actually says that the PIA may be complemented by a fundamental rights impact assessment. So, second point, the importance of conducting impact assessments. As we said before, to identify the risks, take mitigation measures, and then do the reassessment. Third point, transparency. Transparency is essential. Informing individuals, data subjects, about what is happening with the data, the processing activities, whether it is through a normal system, a system where AI is used, or any other technology, because today we're talking about artificial intelligence. Perhaps in a couple of years' times, we will speak about a new technology. So the importance of transparency and fairness.
And that comes out from the GDPR
as well. Yes, transparency and fairness in order to ensure that the fundamental rights are protected and guaranteed.
Good. Thank you, Ian.
More than welcome.
That's it for today's episode. Thanks so much for listening and viewing this episode. If you want to learn more about FRIA or what the IDPC is doing around AI and data protection, check out our website or follow us online. See you next time on the IDPC podcast.